Hello everybody, I'm Kaylee Anderson, Deputy Public Defender in Tulare County, and today we're going to talk about restraining order violations and defending them. But first, signposting. It's very important to signpost your incredibly boring PowerPoint presentation so people know, number one, how close to the end you are, and number two, when you're getting to the stuff that they actually care about instead of the boring stuff they already know. I am going to go over some stuff that probably you might already know, basics of how restraining orders work, both theoretically and in real life. And also, I will then get into the actual stuff you might care about, tactics, tips, including a pet defense of mine, which, believe it or not, in my jurisdiction anyway, gets me not guilties and dismissals on about 90% of all restraining order violation charges, believe it or not, so stick around for that. But first, the boring stuff. We're going to go over to the different kinds of ROs here. You've got CPOs, which are issued by a criminal court. You've got domestic violence restraining orders, which are typically ordered by family or civil court, depending on your jurisdiction. Emergency protective orders are typically issued by police on the scene of DV. Civil harassment restraining orders issued by civil court. And you've got a bunch of other various miscellaneous kinds of stuff that we'll only touch on very briefly. But first, some important definitions. Abuse, first of all. Abuse is in Family Code 6203 and means any of the following things. Number one, really battery is what this means. Technically, it's intentionally or recklessly causing or attempting to cause bodily injury, but really this just means battery in practical, real life. Number two, sexual assault. Number three, the common law version of assault, so putting someone in reasonable apprehension of immediate injury or death or whatever. That will work just fine. You wave a gun in someone's face, obviously. And anything in this list from Penal Code Section 520.5 or 529. Domestic relationship. What is a domestic relationship? This will be an important definition for a lot of our domestic violence statutes, so let's go over it. Anything in this list is a domestic relationship. Spouses, ex-spouses, cohabitant, ex-cohabitant, current or ex-fiance, current or ex-boyfriend, girlfriend, baby mama, baby daddy, including alleged baby daddies, siblings, step-siblings, parents, step-parents, children, step-children, grandparents, and step-grandparents, grandchildren and step-grandchildren, current parents-in-law, not ex-parents-in-law, and current children-in-law, not ex-children-in-law. Family Code 6211 if you ever want to look at that long list again. So the most nebulous of these is ex-boyfriend or girlfriend or current boyfriend or girlfriend. And I misspelled statutorily there, but who cares? The California legislature has tried to define what being boyfriend-girlfriend is, and that means, quote, frequent intimate associations primarily characterized by the expectation of affection or sexual involvement independent of financial considerations, Family Code 6210. Usually that means sex. If you have ever had sex with someone consensually and money was not part of the transaction, then they are or were your boyfriend or girlfriend according to Family Code 6210. This sort of has a hole in it because I feel like there's a one-night stand defense there. You could say, yeah, we might have slept together, but we did not have the expectation of affection or sexual involvement independent of financial considerations. Because it was only a one-time thing. But I've never seen that litigated. If there was no sex, then it gets kind of difficult. If you have said, yeah, we were boyfriend-girlfriend, then you'll be stopped from denying it probably. Otherwise, it's kind of case-dependent. Depends on your age. Depend on, how much you've been hanging out, what kind of stuff you've been doing. The court will look at it and basically decides it knows a relationship of this kind when it sees it, or not. Okay, we're going to start with emergency protective orders. This is Family Code 6240 at SEC. The form usually uses the EPO 001. Typically this happens while the police are investigating DV. They'll roll up, they'll see DV happening. If the victim is pretty obvious, usually, it depends on your officer, but if the police believe they've got a pretty good read on who the bad guy is, they will call up a judge who has their phone on for just such an occasion, even if it's 2 a.m., describe the situation briefly to the judge and get permission to issue the order. And then they'll serve it on the restrained party right there. They fill out the forms. I have yet to hear of a judge ever denying an EPO on police request. EPOs may be issued by a judge ex parte upon an assertion by an officer that Number one, someone is in immediate danger of domestic violence. based on allegation by a protected person of abuse or threat of abuse of that person. Remember our definition of abuse earlier. Or B, a child is in imminent danger of abuse based on the allegation of a family or household member of abuse or threat of abuse of child. So the difference between those two things is that number one, it has to be the protected person, and in number two, it can be someone on the child's behalf. And three, or C rather, is identical to B, except it's abduction instead of abuse. And D is an elder is in immediate danger of abuse. And here we have a slightly different meaning of abuse. It's in 15610.07 of the Welfare and Institutions Code for this abuse, but not just financial abuse. All right, so we'll go over a little bit more about emergency protective orders. Its scope and limits: can protect any child abuse victim, DV victim, or elder abuse victim. It usually consists of a stay-away order with a standard range of 100 yards. Unless you hear me say otherwise, all stay-away orders generally are going to be 100 yards unless the judge specifically says otherwise. And you have to stay away from every member of their household, anyone who lives with them, and also their work, their school, anywhere they regularly go to, and you can't contact them either. So the no contact order will generally mean you can't get in touch with them by text, by phone, by email. You can't send third parties back and forth, no Facebook messages, no contact whatsoever in any means. You can also do anything allowed ex parte under Family Code 6320 to 6322. It's required to deprive the restrained party of the right to possess firearms. So if you get an EPO, you have to turn in your guns. And it must also prevent them from taking action to get addresses of the protected party or their family members. Usually this isn't a big deal because, they were both living together anyway, but you never know. If there are kids, you can make temporary custody dispositions, and the same goes for pets as well as kids. If they live together, the restrained party can be kicked out. But remember that for this to happen, and this is true of all kick-out orders in restraining orders, the protected party who wants the other party to be kicked out has to have some legal right to possession of the premises. If they own it, they pay some of the rent and mortgage. If the name is on the lease, that's probably what it means. If the other person, if the restrained party owns it, then you can't kick them out of their own house, basically. EPOs expire after 1 week, and there are no extensions, most importantly. And they must be served to actually have force. All right, so DVROs we'll go over next. DVROs are a little bit different. They're governed by Family Code 6300 at SEC. There are two kinds. This is important. There are temporary and permanent DVROs, which are the DV-110 and DV-130, respectively. They are sought ex parte before a court, not by the police, but by the protected party, and the temporary ones last until there can be a noticed hearing, and then after the noticed hearing, a permanent one may issue. They generally have the same kind of, or they deal with the same kind of stuff as EPOs do. It's just that they don't have any automatic termination date. Temporary orders will generally last you until the hearing, and then the permanent orders will technically last a fixed number of years, typically, but they can last indefinitely if a court regularly decides that the order needs to keep happening. Permanent orders can only be issued after a noticed hearing. All right, so let's move on. How do you get a DVRO? You have to show that you've been abused and that you're in a domestic relationship. Those are the two requirements, abuse and domestic relationship. Unlike EPOs, they have to be backed by pleadings. Every county I practice in requires the use of the judicial counsel forms, DV-100, and so forth for this. Typically, larger counties tend to have legal aid services that will do this for people. In San Diego, for instance, there are several located throughout the various courthouses, which are not run by the court, but they're run by, in San Diego, the SDVLP, or Legal Aid Society. Shout out to Christine Pangham, by the way, who is the best of these clinic workers. Moving on, in any event, they are typically pro per, the folks who go and get these. They don't generally have lawyers, otherwise the lawyer would just direct file the forms. Like I said, San Diego County has lots of volunteer organizations. That's the county I come from. The county I now practice in, Tulare County, does not have a lot of help for pro pers trying to do this. So typically what happens is judges will review the ex parte pleadings as filed by the petitioner. They will scan for the two elements. They will check off abuse. They will check off domestic relationship. And if they see those two things, they will grant the temporary TRO. If it's borderline, and there actually are a lot of borderline filings, like, oh, he's mean to me, he yells at me, he calls me a bitch sometimes, da 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 da. It depends on the judge. Some judges are really, they err on the side of caution, and they will always issue it if they have some kind of case, because it's potentially bad for you if you don't issue one and then they end up dead 2 weeks later or whatever. And some tend to err, to their credit, on the side of saying, hey, restraining orders are serious business. They restrict your freedoms. They can affect your job. They can affect your INS status. So I'm not going to issue this without some more solid evidence. All right, so what can a DVTRO do? They do the same kinds of things EPOs do. Stay away orders, no harass orders, no contact orders, kick out orders. You can't have guns if you're restrained. And temporary custody dispositions can be made. One thing DVTROs tend to do, usually more likely, or I should say just more likely in general, is they can create travel prohibitions if you believe that the abuser is going to abduct children. And it can require a few things. It can require you to turn in your password. It can require you to post a bond if the court decides to let you leave with the children at some point. There are a lot of interesting measures that a court can take to prevent you from abducting a child. Expiration of a temporary TRO is not automatic. It happens technically on the date of the noticed hearing, but the court can typically extend it. So they don't expire just because, the day of the notice hearing came and went without a decision. Because usually if it's going to be continued, if the hearing is going to be continued, the judge will just extend out the temporary TRO. Okay, so the petitioner gets to decide usually what relief they want to seek, except they can't waive the stay away part, the no contact part, the no harass part, and the no guns part. Other than that, they can kind of pick and choose from the buffet of what they want. As usual, they have to be served on the restrained party to take effect. The interesting thing to note here is that unlike CPOs and EPOs, DVROs have to be served by the petitioner, or not by the petitioner, because obviously that would run afoul of service rules, but it's the responsibility of the petitioner to see that it gets served. So they have to find someone above the age of 18 to go over to the restrained party and hand them the paperwork. So this means that indigent propers are often the ones trying to attempt service by passing it off to a family member or a friend or something. All right. Judges do not like to tamper with custody orders if a family court has jurisdiction already. Some judges don't like to tamper with custody orders at all. They'll just deny the custody parts of it until the noticed hearing. So that's how we get restraining orders. How do they become, or that's how we get temporary restraining orders. How do they become permanent restraining orders? So again, when you get your temporary restraining order, the judge will create a hearing date. You have to serve the other party with notice of that hearing, and here's what can happen at that noticed hearing. Number one, very commonly, neither party shows up, or only the respondent shows up, in which case dismissed, the order terminates. Number two, only the petitioner shows up, but they haven't served respondent. This actually happens probably more commonly than anything else. The judge will typically say, hey, I can't have a hearing if you haven't served the other party. I can give you more time to serve the other party if you want, and we'll continue out this noticed hearing. And the petitioner might or might not want to do that, but judges will generally not let it happen too many times. They'll just terminate it if service isn't happening. Number three, only petitioner shows up and there's proof of service. In this case, they get whatever they want. Whatever they asked for in the restraining order will issue a permanent one, and the judge will decide on the term of that order. And lastly, you can have both parties show up, rarely, in which case a contested hearing ensues, which is like a little mini trial. The rules of evidence apply. They bring witnesses, cell phone evidence, that kind of thing. Permanent DVROs are issued for typically 1 to 5 years, and you still have to serve those, even if the other party didn't show up. You have to serve them with a permanent restraining order as well. They will usually do the same things that the original temporary restraining order did. Judges might be more likely to grant custody orders here. The family court might weigh in, and the judge may choose to modify it from the temporary order to the permanent order if they feel the evidence warrants it. All right, so we're starting to get into the more minor kinds of restraining orders here, so we're just going to breeze through these as fast as we can. Civil harassment restraining orders are basically the same as DVROs, except they don't require the domestic relationship, basically. Um, they are for people you're not in a domestic relationship with. The scope is more limited. They can only do stay away orders, no contact orders, no harassment, no gun orders. Obviously, things like child custody isn't going to be encompassed by a civil order. And it same has the limited permanency of 5 years or less, but usually it's less than that. Code of Civil Procedure 527.6 is the main statute, and those are the forms. Elder and dependent abuse ROs. Keep in mind that for the purposes of these, elder means 65 or older, and a dependent adult is someone 18 through 64 but who has disabilities, which make it impossible for them to lead normal adult life or protect themselves. And abuse also has a different meaning here. It's all the usual stuff that's abuse, plus neglect, financial abuse, abandonment, isolation, abduction, and anything else that might cause physical harm or serious mental distress, even if you're not directly punching them or whatever. Also, if you have a duty to the adult, if you're a caregiver or something, and you neglect that duty resulting in their distress, you are abusing them. Other than that, it's exactly the same as a DVRO. You get a temporary to order ex parte and a good showing of likely abuse. Then you have a noticed hearing that you have to serve them with, so on and so forth. And it's the same: no contact, no harass, blah blah blah. Welfare Institutions Codes 15610.07 is what we're looking for there, and those are the forms. Workplace violence ROs. These are weird because the employer tries to protect their employee from a third party. Normally, the employee would just get a civil harassment restraining order, a DV restraining order. The thing that's interesting about these is that a workplace can protect their employee without the employee's consent. They have to show that the employee has suffered unlawful violence or threats of violence. Some exceptions there. And again, the format's the same. You have a temporary one, then you have to serve them. There's a noticed hearing to see if it should be permanent, blah, blah, blah. Those are the forms. That's the statute. Gun violence ROs are also rare because usually if you want to take away someone's guns, you also want to keep them away from you. They are just basically ROs with just the no gun part, and they don't do anything else. You have to show that they're likely to hurt themselves or another person with a gun. There are emergency gun violence ROs that are similar, I should say, to EPOs that are issued by the police. The police can take your guns and say, hey, we're taking away your guns because you're using them irresponsibly. You'll get them back in such and such time. Usually this is used when you have someone you think is being an idiot with guns, but you aren't really afraid of them other than that. And they follow the same general outline. First there's a temporary one, notice the hearing, blah, blah, blah. And statutes and forms are there for you. All right, now let's get to the important one for you as a public defender, CPOs, Criminal Protective Orders. They are very different from the other kinds of stuff we've just been talking about. There's no petitioner, no one seeking the order, no respondent, someone trying to fight the order. There's just a judge and a restrained party. All right, so these are issued by criminal courts during criminal proceedings, and they fall entirely within the discretion of the judge of the criminal court. Usually they enjoin the criminal defendant from doing stuff, but they can also enjoin any, quote, subpoenaed witness or other person entering the courtroom under certain circumstances. So anyone who walks into a courtroom during a criminal case can technically be subject to a CPO if there's good cause. These are the three statutes that generally you're going to find CPOs issued under. 136.2a, which covers pre-sentence CPOs, and then these other two, 136.2i and 1203.097, which are both post-sentence. More on that later. That's an important distinction. There's your form, CR 160. Typically, it'll be attached to the minute order. All right, so pre-conviction, 136.2a controls. The judge has to have good cause to believe that a victim or a witness will be harmed, dissuaded, or intimidated. You can then do the following things. Number one, do anything a DVR can do to the defendant if he's the threat. To order anyone who enters the courtroom or any subpoenaed witness, basically anyone the court has jurisdiction over, or can assert jurisdiction over, to have no contact with a threatened witness or victim except reasonably through an attorney. And order anyone not to violate 136.1, which is the dissuading a witness statute, but that's a crime already, so, who cares? And this is an interesting one. Order the police to provide specific protection to the threatened person in ways that the judge can kind of custom tailor. And then if the agency objects, which they often do, it has to be narrowly tailored, and the judge has to have findings of good cause and so forth. And you can always order a hearing on whether or not we're going to issue a CPO and so forth. All right. So if you've been a public defender for really any amount of time, I mean, if you've dealt with more than 2 DV cases, chances approach 100% that you've heard this question at some point. These are the orders that domestic violence alleged victims are always begging us to get lifted. Remember, you do not represent the victim. You represent the defendant. You represent your client. Think about what is best for your client, not for the victim. And seek your client's direction and advice about what they want. Usually they're going to also want the order lifted, but that's not always the case. Use your judgment. So typically judges will only lift them, and they will lift them, if the victim gets up there and says, hey, I don't really want him to be forced to stay away anymore. I don't want him to be forced to not contact me at all anymore. I would just like a no negative contact order instead, where we can be together and we can hang out, but he can't, yell abuse at me. Here in Tulare, there's a class offered for DV victims, which basically the DA makes them go to, and judges want to see them go to before they'll modify the order in this way. Judges also will lift them, keep in mind, if there's no good cause to suspect that there's any real threat. So if they think your case is bogus, oftentimes they will deny it. Some judges, such as Judge Gorelick in Tulare County, are sticklers, and they will require that the victim not only complete the class, but give the people the required written notice of the hearing 5 days in advance. Judge Gorelick here in Tulare County usually uses this to keep from having to rule on this if he thinks that it's not a particularly good idea for the victim to lift the no contact order. So if they're under a no contact order and the victim rolls up and Judge Gorelick thinks they're not being rational, or thinks they're not looking out for themselves, he'll say, well, technically you've got this written notice requirement that you've got to comply with. And he is correct, there is that written notice requirement. In cases like that, if you want to force the court to rule on it, then you can notice the DAs that you're seeking a change, and then during your request to change it, you have the victim come in and describe it if they want. But keep in mind that the victim is not your client. Your client's your client, and advocate for their interests. All right. So when the victims are children, things can be a little different. In child abuse and endangerment cases, the restrained party may be a parent, who is restrained from contact with their children, obviously. If there's a dependency proceeding in progress already, the criminal court will typically defer to the dependency court. They're not going to go messing with whatever the dependency court is doing. And they'll say, we'll order contact or we'll order visitation consistent with whatever dependency court says. If CWS hasn't gotten involved and there is no dependency court proceeding, then the criminal court will generally act with wider latitude, and they'll assess what type of crime is charged. They'll assess, what kind of harm might have been suffered, and this is where you have to dig in and do some good lawyering for your client. You want your client to do stuff that makes them look like less of a threat to their children. They can do programming, parenting classes, get counseling, that kind of thing. That will all increase the chance that the CPO will be lifted or modified, and maybe down the road at sentencing, if there is sentencing, you can point to all the wonderful counseling and parenting classes that they've done. Okay, so after you get convicted, you can still be subject to a CPO. We'll start with 1203.097. This applies in domestic violence or child abuse cases. Again, we'll start with 1203.097. If you get probation and you're convicted of domestic violence, you must, as a term of probation, be subject to a CPO, which at least is a no negative contact order, and which can go full, complete no contact, stay away, kick out orders, and so forth. And it has to last for as long as probation does under 1203.097. There's also 136.2i. Regardless of any other sentence, regardless of whether there's even probation at all, the court can issue upon conviction, independently and in addition to a 1203.097 order, a no contact order but it can't do anything else. It can only be a no contact order for up to 10 years post conviction. So you can reject probation, you can get 10 days in the county jail, and the court can say, but by the way, no contact order for 10 years, bam, even though you rejected probation. The court must always consider making such an order technically, and it must base its decision and the duration of the order on the seriousness of the facts, the probability of future violation, and the safety of the victim and their family. You can also, again, even if the person doesn't go on to probation, require electronic monitoring of the defendant for up to 1 year to ensure compliance and have the defendant pay for it if able. All right, so some other things to look out for with regard to ROs. Remember that they can hurt your clients in family court. If you go to family court and they find out that, oh, you've been subject to a restraining order for X, Y, and Z, even if it's a temporary order, that can look bad to family court. But of course, we're not family lawyers, we're criminal lawyers. They can have immigration consequences, particularly when the client is seeking naturalization already or is already the subject of immigration proceedings. Typically, this isn't the kind of thing that's going to cause INS to come looking for your client. It's when they already have immigration stuff they need to worry about that this is going to hurt them. But again, we're not immigration lawyers, or at least supposedly we're not immigration lawyers, we're criminal lawyers. They can linger in CLETs or other information databases after they expire due to shoddy record keeping. And this can happen in suppression hearings where police honestly thought there was a probable cause to detain, or they thought, because your guy, let's say has a restraining order, the restraining order expires, they go near the person, the police see them there, they're like, oh, he's near that house he's not supposed to be near according to my database, I better go search him and arrest him and stuff. And keep in mind the good faith exception to the exclusionary rule, and I've got some case law there for you. All right, so that's all the boring stuff. Now we get into the meat of this stuff and we find out how we use all this information for justice. Why do you care about this stuff? Number one, you might care because your client's restrained by these orders while you represent them. Violation of those orders is an offense under the criminal law, and you are their criminal attorney. Number two, because your client is restrained, wants not to be restrained, and you have to try and accomplish that. Number three, because your client may need a restraining order. And number four, because the reason that they're your client in the first place is because they were charged with violating a restraining order. All right, so we'll start with the first of these situations. Advice to give any client who's restrained by a restraining order. Number one, do not violate the restraining order. Number two, seriously, for real, don't violate the restraining order. You can go into great detail about consequences because there is a little bit of a problem with recidivism for some clients when it comes to violating restraining orders. They tend to not take it seriously. They tend to go back over, particularly when the alleged victim invites them back over. Seriously, even if the protective party calls your client or shows up at their house, that doesn't get rid of the restraining order. There's no defense of, oh, but she came over to me, or oh, she called me. You still are restrained, and you have to act like you're restrained. The thing you should advise them to do is just hang up, shut the door, don't talk to them, and say, hey, I can't talk to you, I'm restrained by this restraining order, you got to get away. And if they persist, call the police, and maybe they're trespassing, maybe they're harassing you. Just call the police first before the other person does, and explain the situation. Hey, I'm restrained by this person, but they're bugging me. I'm supposed to stay away from them, and they're not staying away from me. If you are not a U.S. citizen, then you should be advised by your lawyer that you might need the advice of an immigration attorney, especially if you're trying to naturalize. Or if there's already an INS hold, you can tell them, hey, this RO might hurt you. Although if you're the client of a public defender, typically you got bigger fish to fry than just the restraining order. All right, so some of your clients are going to need restraining orders. Don't overlook this. Sometimes you're the only person who will be able to see that your client needs a restraining order. You're the only person who will see the abuse. Remember that your client is a criminal defendant, and thus, according to prosecutors and society at large, is a quote-unquote bad guy and won't be considered as being a potential victim of abuse. But very often, or surprisingly often, your client will be the real victim and the other person will be the abuser. You fight this in the criminal case, but remember that not all your remedies may come inside the criminal court. You can send them to a clinic, and you can also get, and by a clinic I mean a clinic that does DV restraining orders or whatever. But you can also get criminal protective orders protecting the defendant in the criminal case. Recall that under the law, anyone who walks into a courtroom is potentially restrainable as long as they are a threat to a potential witness, and your client is a potential witness in their own case, basically. There's the statute to cite if you ever want to do that. If something's happening and you want to tell your judge, hey, I need a CPO protecting my client from such and such a person, that's the authority you cite. But remember that you can't go and fill out the DV 100 for them or whatever, because that's not criminal law. That's beyond the scope of your criminal practice, if you're a public defender anyway. If you're a private attorney, you may choose to do that for them. But even if you're a public defender, you can refer them to resources. There's a useful URL for you. Usually courthouses will at least point you in the right direction. The clerks will be able to tell you where to go for this kind of thing. Again, around here in Tulare County, there are not a lot of places that will help you in filling out the DV 100 or whatever request form for whatever restraining order you're seeking. All right, modifying a CPO. If your client's restrained by a CPO and you want to remove it or change it, you have to convince the court that your client's not a threat. The court can technically do this against the wishes of the protected party, but it will never, ever, ever do that because courts are really scared that if they remove an order, when the victim says, no, 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 I don't want it removed, then the victim will end up dead or raped or whatever, and then all the newspapers come and they hang your judge high, and they don't want to be that judge. So really, to get a CPO changed or removed, you will need the alleged victim on your side. Very often alleged victims want to help you and want to be on your side, but that's another MCLE about defending domestic violence charges rather than restraining orders. But even when you have the alleged victim on your side, judges can be pretty skeptical of whether or not that's in the victim's best interest. They know that love does some funny things to the brain, and that alleged victims are often a little bit too eager to get back together with their alleged abuser. So you have to advocate for your client, show that they really are not a threat. You have to overcome that skepticism. Some of the ways you can do this. Classes and programming are always great. If the victim has completed classes or programming, that can help too. If they have a long, peaceful history, that really helps. Like if they were living together for 30 years and this was a one-time thing. Particularly if they have kids together and they're good parents. If they, have this, bright, shining 7-year-old, it usually goes along with a long, peaceful history. If there's a third party that can come in and ensure peace and stability, if they're going to go live with one set of parents or another or something like that. If you're trying to avoid the issuance of a stay-away CPO in the first place, you can point to the fact that they've lived together peacefully since the incident as a good fact as well, if that's true. Really anything that makes your client less of a threat is something you want to point to. And it's not just less of a threat, it's just a nicer person, like, oh, he volunteers at charity or whatever. Some judges will wave that off as, yeah, but what does that have to do with them being a threat in this case? But really you want to point at anything that, makes your client seem like a nicer person or less likely to be a terrible abuser in the judge's eyes. All right, so defending against RO violations is the fourth situation. If your client is your client because they were alleged to have violated a restraining order in the first place. In Tulare County, this is Penal Code 273.6 or 166 is how the DAs like to charge it. Both of those tend to be misdemeanors. One of them can be a wobbler, but they're usually misdemeanors. Even though they are misdemeanors, usually they are really good ways to foul up your felony probation or parole. Courts do not like it when you violate their restraining orders because most judges will say, weren't you here in this courtroom when I told you not to do X and Y and you did it anyway in direct violation of my order. And so this is a great way to have your probation revoked or your parole revoked. And even more so when the violation is of itself really bad. If, for instance, if it's a no contact order and you go, full rage mode and there's a bunch of profanity and threats to kill, then you'll be in a lot worse shape for that kind of thing. Whereas you might get a little more lenience if it's technically a violation of the no contact order, but it's kind of harmless, like the single 2 a.m. drunk text. But remember that any violation is a crime, even if it's just the hey baby just thinking about you, and all that stuff can put you in jail and violate your probation if the order was valid. And yeah, here's the wobbler. 273.6 with a prior of 273.6 is a wobbler if the prior happened within 7 years, but only if the new offense involves actual violence or a credible threat of violence. 273.6D is where to look at. Okay, so how do you defend your client from alleged RO violations? Defense number one, client didn't do it, obviously. Usually there's not going to be too much of a fuss around whether your client actually made the call or was within the 100 yards, because the police officer will have arrested them in the first place because there was credible evidence that they were found near the house, or that they made the call or whatever. But sometimes the protected person just says, oh, hey, yeah, they called me 10 days ago. Yeah, definitely. Oh, I don't have any proof of it, but they definitely called me. It certainly has nothing to do with the fact that, they have a new girlfriend now. Sometimes that happens. Fight it when that happens if there's no evidence. Keep in mind that some judges like to custom tailor the scope of their orders. A very common problem comes in when judges say, I'm going to allow contact, but only for co-parenting purposes, or only for the purposes of pickup and drop-off of children during visitation. Then you can get into some pretty nebulous loopholes about what that means. This is not a direct quote from a client of mine, but it's awfully close. I had a client who basically was allowed to contact the mother of his children only on matters that had to do with the welfare and upbringing of the children, and he said something sort of like that, and there was some dispute about whether that fell within the scope of what the order allowed. All right, and if that happens, usually you want to get transcripts from the court that made the order. You want the exact wording of what happened in the court that day, rather than just the vague minute order. But you already knew that they didn't do it as a defense. You probably know how to do that already. You came here for tricky lawyer business, little technicalities and little traps that might get you an unexpected win. So I'm here to do that for you. Number one, don't forget about service. No one is ever guilty of violating a restraining order unless they were served with that order. Typically, if they're alleged to violate that, if they are alleged to have violated a CPO or EPO, you're not going to have a service problem, because the court would have just, done it in open court, or the police would have just handed it to them. But that doesn't mean that problems are impossible. With all other kinds of restraining orders, especially DVROs, remember that a non-lawyer, probably pro-per civilian, had responsibility for service, and usually that means, well, not usually, but often it means that service was screwed up somehow. So keep an eye out for that. Now, some counties do allow their sheriff's departments to serve, particularly DVROs, if the protected party requests the sheriff to do that, but not all of them. I don't know how it works in Tulare County still, because actually DVROs and such are pretty rare here because we don't really have the resources to help people file them. Remember the basic rules of service. Under the Business and Professions Code, the server has to be an adult and not a party. So that means the actual petitioner can't be the one serving it. It has to be someone else. It has to be an adult too. And it has to be personal service. No mail service, no fax service. You have to go up to them, hand them the papers. If any of these rules are violated, then service was screwed up and the order may not work and may not apply to your defendant. Keep in mind that even in probation cases, if service was improper, you may still violate the term of your probation even if you're not guilty of a new crime. So for instance, if let's say you have as a term of probation stay away from them, but also you have a DV restraining order saying stay away from them, and you can prove that the DV restraining order wasn't served, you might still have a VOP just because it was a term of your probation. even if you're not guilty of the new crime of violating the restraining order. So the first thing you want to look for when you're checking services, look for the proof of service filed with the court. If you can't find one, if the DAs don't know where it is, if it doesn't exist, then the order is invalid. Well, not invalid, but it doesn't apply because jurisdiction was never asserted. If there is proof of service, make sure it checks out. You want to see if the appropriate person served it, first of all, someone who's an adult, not a party to the litigation, and you want to make sure that they actually served it. Sometimes people signed the proof of service who did not actually do the service, and you want to make sure that that isn't the case. So check with your client and check with the server, and determine whatever evidence you can to figure out whether or not it occurred. And of course, if they're lying about service, then the order has no force. No police officer yet that I know of has lied about serving an EPO, but that doesn't mean it can't happen. So remember, this might happen even with EPOs. So I've often heard it talked about that restraining orders are violations of due process, potentially, because a lot of them can be ex parte. DV restraining orders can put some pretty serious restraints on your liberty without any process whatsoever. Just as soon as you're served, bam, you have limitations on your movement, limitations on your firearm rights, things like that. I haven't seen this advanced as a defense to, like, for instance, a temporary restraining order violation, but it might be worth a try. And I don't have any materials or briefs or anything for you because, again, I've never seen it litigated, but just keep in mind that this is out there. And remember that this has more force if the court should have customized the order for good cause. Like if you can point to something where you can say, well, if the court had had a hearing and actually considered it, then it would have realized that 100 yards was a bad number and it should have been 75 yards instead because that's how far away my client lives from the person or whatever. That strengthens your case. And even without using it as a defense, remember to ask for things like that, by the way. If your client lives only 75 yards away from the restrained party, remind the court of that and tell them, hey, can we customize the order? And most courts will accommodate you. Intent can be a defense. If your client was found at the victim's house and they knew that was the house, probably you will not have an intent case. But sometimes your client might not actually have had intent because they were just coincidentally perhaps at the same place. Malls happens a lot, parks, this can happen a lot, any open public place. So if if your client and your protected party are both wandering around in a mall, the prosecution has to prove that the client knew the protected person would be there. And that can be hard to do. Now, sometimes, you'll have some bad facts, like the client might have a bunch of creepy pictures of them at the mall on their phone, or a bunch of texts saying, hey, I'm going to go stalk victim now over at the mall. So that's not great. Or if they can prove that the client, talked to the victim or something, that's not great. But sometimes the victim just sees the client and goes, oh, hey, it's that person. I have a restraining order. I'm going to call the cops. Then if they can't prove that your client knew the protected party was there, you have a case. All right. So this is the last thing I'm going to talk about. This is the really tricky defense that, in my jurisdiction anyway, works about 90% of cases having to do with restraining order violations to get an NG or dismissal. So pay attention here. Illegal CPOs. Remember that criminal protective orders are governed by statute and case law. And this law is extremely specific about what kind of CPO you can issue and when. So let's review. 136.2a orders protect the victim or witnesses during the pendency of the criminal proceeding. They usually are issued at arraignment and they're served at that time. The other two kinds of orders, 136.2i and 1203.097, protect the victim post-conviction. And when I say conviction, I mean sentencing, by the way. 136.2a happens before sentencing, and everything else happens after sentencing. They are issued at conviction, but again, that means sentencing. Most judges, at least in this jurisdiction, and I know in several other jurisdictions as well, don't really get this distinction, and they just kind of know, oh, I can issue CPOs at any point. And a large number of judges, even when they do appreciate this distinction, don't take the time to make a really clear record about what they're doing, or to make it clear to their clerks what they're doing. And clerks are not well equipped to understand this distinction either, and so that might lead to orders which don't distinguish at all between 136.2a, 136.2i, and 1203.097 orders. So this is what happens in a typical case. The judge will issue a CPO at arraignment. The CR 160, which is the CPO form, will say, quote, pursuant to 136.2, without specifying which subdivision we're talking about. But because it's issued at arraignment and has no specified termination date, that means it's a 136.2a order, which is applicable pre-conviction, so that makes sense. Now, if the defendant is convicted, the judge then usually at sentencing say something like, oh, okay, so the CPO is going to keep applying, you have to keep staying away. And very often, the judge will not issue a new CR 160, and they'll check the minute order box that says CPO remains. In Tulare County, that box is on the 10th line down. So what that means is that the judge, whether they intended to do so or not, just purported to have their 136.2a order from arraignment remain after conviction. Unless it's certain judges, I've X'd out their names. Judge XXX well, that's Judge Gorelick in Tulare, or another judge back in San Diego who doesn't do criminal cases anymore. In that case, the judge probably saw to it correctly that the order was issued properly, because Judge Gorelick understands this distinction. And then sometimes they complain to me about how I'm wasting their time by making them issue a whole new order, since apparently I'm going to defend my defense acquitted. So this is a total vent. More so about the San Diego judge than about Judge Gorelick, because Judge Gorelick, I remain convinced, knew full well about this distinction before I ever pointed it out to him. The other judge did not, and the other judge liked to complain at me all the time after I got my first defendant acquitted using this problem. All right. So what does this mean if your court tried to get a 136.2a order to continue past conviction? What does that mean if your client's now accused of violating that order? It means your client's not guilty, straight up. Here's your case law right here. Write it down, copy it, have it ready, cite it all the time. These are probably my 3 most cited cases right now, other than, like, form cases that I put in my Wilder motions or whatever. When it comes to actually mentioning cases in front of judges, these are the 3 cases I talk about the most, because these 3 cases say straight up, you have to issue a new restraining order. You can't just say the order from arraignment remains. You have to issue a new one, and you have to be very specific about it. Ponce there, the last one, is a particularly nice case for us. There, some deputy attorney general got really creative and threw a bunch of stuff at the wall to try and protect this 136.2a order that was tried to keep at conviction, and the court just said no, you always have to issue a new one. So keep that in mind. If it's a 136.2a order, and your client is accused of violating it after they were convicted, then you win. So here's how you find this issue. First of all, anytime your client is accused of violating a restraining order of any kind, you need to figure out what that order is. Usually the complaint's going to be a little vague, but you can usually figure out by searching through court records whether it was a CPO, a DVO, an EPO, or whatever. And remember, you can always discovery request this information from the DAs. They'll have to provide this to you. Now, if it's a CPO, you want to find the documents for the case where the CPO was issued. You want to find any sentencing minute orders. Go to the sentencing. Now, if your sentencing says new CPO issues under 136.2i or 136.2097, then you lose. But most of the time, at least in this jurisdiction, there will be no new CR 160 form and it'll just be a minute order that says CPO remains, or it'll just be a sentencing sheet that says CPO remains. And if that's the case, then you probably just won the case, or at least that count. So if you have that, you need to go back to the arraignment and find the original CR 160. And again, it'll probably just say it's issued pursuant to 136.2 without specifying a subdivision. And it won't have an expiration date either. And if that's all true, then you win. Now, it doesn't have to follow the script exactly. Sometimes the sentencing minute order will say CPO remains, but also CPO issued. Then you still might have a good case, because the statutes that are about post-conviction CPOs have to be explicitly identified, and point to I orders require the court to make specific findings of good cause, and if there are no specific findings of good cause on the record, then you've got a good case. So how do you go about winning the case? There are a lot of remedies. If the complaint doesn't specify the type of CPO, if it just says, oh, they violated a restraining order, then you can demur, because even though it might clearly state a crime, they didn't allege jurisdictional facts. You may want to demur in any event, since you're alleging a lack of jurisdiction in the first place, because you're saying there's no valid court order. So you have no jurisdiction. But in any event, regardless of the technicalities of whether demur is appropriate or not, if your client's in custody, Penal Code 991 is appropriate. And I typically, if the prosecutor tries to fix the complaint by saying, oh, it was a CPO which was a 136.2A issued on such and such a date, I'll just hit them with a 991 if my client's in custody. If my client's not in custody, then I ask for a 1385 dismissal. And typically the judge will see my point at some time during this process and try to tell the prosecutors they need to shut it down. Sometimes you have to resort to trials, and the judge will, if they know what they're doing, if they know the problem, will shut the prosecutor down on an 1118 or an 1118.1 motion. Of course, it's possible, I haven't had this happen yet, but it's possible that a judge doesn't see the problem, lets it go to trial, and you get convicted, in which case just appeal it and you should win. All right, keep going. Remember that most judges and prosecutors, at least not around here in Tulare County, most judges and prosecutors don't know what's going on with this issue. And a lot of prosecutors won't understand that they should just completely lose if this is screwed up. Judges are less bad about it. Judges, if you point it out to them and explain to them, hey, judge, I know this is how we do things, but here's how it's supposed to work according to the penal code, and here's why I need to win the case. They'll go, oh, well, that makes sense. I read the law, I see it, message received, I will do it right from here on out. Sometimes you get lucky and you have prosecutors who agree, oh, wow, yeah, look at that. I guess we need to offer a 415 infraction or something, or dismissal, hopefully, but let's not get too optimistic. But sometimes you have to litigate it all the way, and sometimes you have to appeal. I have not had to do that yet. I've always gotten it dismissed, or had the judge throw it out, or have the prosecutor dismiss it. I have yet to lose on this issue, where I thought I had the issue. Now keep in mind that judges will fix this. The first time you get a case thrown out in front of a judge, they will say, oh man, I need to be really careful in the future about doing this the correct way. And typically they'll start doing it right. But that doesn't mean you can stop paying attention to this issue, because you'll still have a bunch of cases coming from the same judge before they made the correction. Sometimes they might get a little forgetful about making the correction. And in any event, you might get orders from other judges. And in our jurisdiction, our district attorney's office, even if the judge starts doing it right, they don't really learn about this issue. They will keep filing on it, even if there's a on its face bad CPO, and even if I've won on this issue 5 times in a row, they'll still try to file it, because that's just the way they are. So just keep doing it. Be vigilant, be persistent, keep checking the underlying restraining order in every single case. And if you do that, then you will keep getting a lot, and I mean a lot, of dismissals for your clients. So again, vigilance is the thing. That's your watchword here for this issue. That's the end of the presentation. I hope you've enjoyed it. I hope you learned something about CPOs, EPOs, DVROs, all that good stuff. And I hope you keep in mind that last bit about when particular kinds of CPOs can apply, because it's a really good trick that will get you a lot of wins. Thanks for watching, and I hope this helped you.